Hi, I'm Gregory Robinson with the Robinson Advocacy Group Professional Corporation in Montgomery, Alabama. I've always been a process guy, and what I love about estate planning is that if you understand and follow the process, you can create the best possible outcome for everyone and everything you care about, no matter what you've earned in your lifetime. Welcome to our masterclass, Avoiding the Inheritance Battle That Sabotages Your Family Legacy. Who is this for? Homeowners or business owners, those who are married, have a blended family, or single again, those who have worked hard or still working to provide for their family or things they value, and those who have children, family, or charitable agencies that they care about. In the next 30 minutes, I'm going to show you how our clients ensure that things will be smooth and simple for their family, confirm that the things they own will go to the people who should have them, how they prevent family disputes over an inheritance, and ensure that biological children do not get cut out of an inheritance, and how they maintain clarity and fairness in the family. And our clients do this without going to court, hiring lawyers, and waiting for a judge to make decisions for them, otherwise known as probate. Even if they wouldn't consider themselves wealthy, even the most modest estate is worth protecting. I know your time is valuable, so here's my promise to you. I'm going to share a process that will help you prepare for the unknowns that life inevitably throws at us, and will protect yourself, your family, and even your family business in the event of incapacity, and ensure that the assets that you've acquired pass along to the people who you want to receive them. I'll show you how my clients avoid the frustrating and expensive probate process that leads to family disputes and a tarnished legacy. If that's what you're here for, then you're in the right place. And we do all of this without giving any unnecessary amount to the Internal Revenue Service. Does this sound like you? Intimidated to work with an attorney? Alarmed to learn that the probate process will last at least 6 months in Alabama? This is the time required to give creditors an opportunity to file a claim to close out the estate. Are you worried about whether or not your wishes would be honored in the absence or incapacity? Afraid that your business would be vulnerable without you? Are you nervous that you might leave a burden on your family rather than a legacy? If any of those scenarios sound like something you've gone through or are going through right now, then I have some good news for you. None of those are the real problem. The real problem is you haven't taken the steps necessary to avoid some of the big mistakes. Once you solve the real problem, you can be confident that you've done everything in your power to ease the burden on your family and leave a clear legacy instead. Today, we're going to be discussing strategies that are dissimilar to conventional wisdom. So you may be wondering, why should you listen to us? So let me take a minute to introduce myself. Again, I'm Gregory Robinson, founder and director of the Robinson Advocacy Group Professional Corporation in Montgomery, Alabama. I'm a native of Alabama, and I served my country as a former Army officer. As a Lean Six Sigma expert, I'm highly analytical, which helps me to be process-oriented. Estate planning is not stagnant, but a process that evolves with changes in the law and your life. Once I find the roadmap for the process that fits your family, I continue to refine it and respond to changes to ensure that the machine runs very smoothly. By nature, I'm a problem solver, and I enjoy helping people find a way out of their problems. I listen, empathize, and gain a deep understanding of the issues. And then I leverage my knowledge to identify a resolution. In addition, my membership with Wealth Counsel provides a plethora of resources that enable me to provide first-class service to my clients. Mistake 1. Thinking a will is all you need. Let me tell you a story about a client who was the surviving spouse of over a 50-year marriage. The client died having a last will and testament dividing her assets unevenly among her 3 surviving children. Shortly after the executor filed a petition to open the estate, the youngest son contested the validity of the will, claiming coercion and duress by his 2 siblings. The dispute between the siblings became very unpleasant, destroying the siblings' relationship and adding months to the probate process. Mistake 2, not protecting your heirs from the inheritance. I knew a family that owned a very successful transportation company. The company operated for over 50 years prior to the owner becoming ill. This very successful business owner did not have a business succession plan and assumed that his descendants would run the business in his absence. He was wrong. After his death, his family was ill-equipped to run the business. His wife didn't like the industry and wanted nothing to do with the business and let her oldest son take over. The son was a spendthrift. Within 2 years, the company was bankrupt. Mistake number 3, not using the secret weapon. The Robinson advocacy process is a proven system designed to take care of your family, your assets, your business, your wishes, and everything that's valuable to you. It's a comprehensive estate plan that fits you like a tailor-made ensemble. Let's do a brief recap. The first 3 mistakes were thinking a will is all you need, not protecting your heirs from the inheritance, and not using the secret weapon. Now, before we move on any further, I want to talk about the old way of planning. These are the things people used to do, and unfortunately, all too often, still do. These things can prevent the outcome you would have wanted. The old way is onerous, time-consuming, expensive, and complex. Doing nothing. Let the courts figure it out. There is no assumption that the planning will ever get done because we're basically saying that, what do I care? I'll already be dead. Have joint accounts with your children. Or assume the business will run itself after you're gone. Lacking a proper business succession plan or assuming that a certain person wants to or will take over the business sets up major financial problems later for the family. Belief that life insurance solves all your problems. Assuming that making your children the beneficiary of a life insurance policy will provide for them in the future is a big mistake, because the benefit gets taxed, it may get lost or misspent. And lastly, just a will. Be fine with probate. People just feel like it's fine to allow their assets to go through probate, but it's like filing a lawsuit against your family. Does this make sense? The methods of the old way are irrational, especially if you have assets and people in your life who are worth protecting. The new way looks like this. The Robinson advocacy process. Step 1, recognize that you have a problem and commit to solving it. Step 2, book a meeting with my office. Step 3, meet virtually by Zoom. And step 4, create your plan and protect your family. Mistake 4, procrastination or do nothing. A close friend whose sister went into a coma called me and asked how could he manage her financial affairs while she was in the hospital because she was single. I explained that he needed to get a conservatorship, but due to the pandemic, the courts were closed. The other siblings threw money together to pay for their sister's expenses, but all the while the brother couldn't get a power of attorney to manage her finances. This woman was a professional with no kids or a partner. and no one in her family could do anything to help her financially. However, the story had a happy ending because my friend's sister recovered, and I was able to prevent the issue from reoccurring by drafting a doable power of attorney, and her brother is now her agent. Fifth mistake, not getting expert help. Case study. LegalZoom. People do it all the time. Many people think, I won't have to pay the lawyer anything because I'll get self-help legal assistance for cheap. I tell clients, if they're intending to speak to the court about what you want, getting the fill-in-the-blank product will not meet your needs. It's the difference between buying a tailor-made suit and a suit off the rack. Estate planning is a specialized area. Just like you wouldn't go to your family doctor for heart surgery, we all have that temptation to do our own planning by thinking, I'm smarter than a lawyer anyway. A lot of younger clients tend to go out and do things themselves, but you want some professional help. Today, I shared a process that will help you prepare for the unknowns that life inevitably throws at us, and will protect yourself, your family, and even your family business in the event of incapacity, and ensure that the assets that you've acquired pass along to the people who you want to receive them. I showed you how my clients avoid the frustrating and expensive probate process that leads to family disputes and a tarnished legacy. And how we do it all without giving an unnecessary amount to the Internal Revenue Service. Mistake number 1, thinking a will is all you need. Mistake number 2, not protecting your heirs from the inheritance. Mistake number 3, not using the secret weapon. Mistake number 4, procrastination or doing nothing. Mistake number 5, not getting expert help. At this point, you have a choice. You can either do nothing or you can take action. Just watching a webinar and getting more information does not solve a problem. The only way to solve this problem is to take action and book a call. So here's what I have for you. My team and I have set aside time in the next few days to speak to you personally about your situation and possible solutions. Whatever your biggest challenges, we've seen them and we can help you overcome them. The cost of the call is absolutely free. We can do this call over the phone, but I really prefer to use Zoom because I found this method works best. During the call, I'll learn a little bit more about your family. We will talk about your concerns and your goals, and we'll talk a little bit about your estate. If I'm confident our team can help, we will lay out some planning options to accomplish your goals. While this breakthrough meeting is free, it's not for everyone. It's for people who are committed to solving the problem, those who value expert advice and counsel. So why are we doing this? In estate planning, there's an epidemic of plans that simply fail and good intentions gone completely awry. The need is high, yet access to planning is so low. The baby booming generation is transferring an unprecedented amount of wealth, and good guidance is needed. Many people don't understand taxes and the effect on their legacy. And lastly, I found out in the height of my professional career that I was chronically ill, and found out that my personal affairs were completely in disarray. So I took an in-depth look at estate planning. People can't put this off, and I want to help as many people as possible. There's a book a meeting button showing up on your screen. Click it now, and it will take you right to my booking calendar. Just pick a time and date that's most convenient for you, and we will initiate the meeting with you over Zoom on the date and time you select. There is absolutely no charge for this call. The Michael Jackson Family Trust is the true governing document of Michael Jackson's estate. Michael Jackson signed the original trust agreement on November 1st, 1995, but the governing trust agreement that existed at the time of Jackson's death back in June 2009 was fully amended and restated version signed by him in March of 2002. Jackson had a pour-over will as part of his trust-based estate plan that poured the assets of Jackson's estate into the hands of the trustees of Michael Jackson Family Trust. John Brannica, a longtime attorney for the Jackson family, was named to serve as the co-executor of the estate along with music executive John McClain and accountant Barry Siegel. Michael Jackson's mother, Catherine Jackson, was named as the guardian of Jackson's minor children. If Catherine Jackson was unable or unwilling to serve as the children's guardian, Diana Ross was to serve. Contrary to popular belief, a will is not required to list anything about the natures of the testator's assets or net worth, and this was the case for Michael Jackson's will. Once again, I would like to thank you for attending our master class and learning about the Robinson advocacy process. Please book your call now.